Well, I just want to thank everybody for coming. My name is Chris Aitken. I'm the chair of the DBA from the law firm of Aitken and Cone. Today, on behalf of the Downtown Business Association, we're very happy to have Javier Carbone. He's going to talk about preparing your business to reopen post the stay-at-home orders, a very relevant topic right now. We're excited to have these webinars. The DBA members have asked for them, and we're trying to help our members with these. Javier is a labor and employment attorney, and he's going to talk to us about getting back to work. Just a quick housekeeping matter. Javier has certainly encourages all your questions. If you have any questions about reopening, he certainly will educate us about where we're at, and we know it changes daily, but we certainly encourage your questions. So if you have any questions, please let us know. And without further ado, I'd like to turn it over to Javier. Javier, welcome. Thank you.
Thank you, Chris. Thank you. And thank you for the Downtown San Clemente Business Association for this opportunity to talk about something that I think is important, which is getting ready to go back to business. And before I begin, I want to say a couple of things. I echo what you said, Chris, that any questions or comments, if they can put it on the chat, we'll do our best for you to read them, because I really can't see the chat. And to interrupt me and just ask the questions, because it's important to have those questions answered. The state, the US government, the county, they have all issued some guidance on how and when to go back to work, which has made it, in my opinion, terribly confusing, because some of those rules, guidelines tend to be inconsistent and to conflict. So part of what we're going to do today is to try to have some clarity on what it means to look at all these guidelines and try to follow them in order to open for business. So Chris, what I would like to do is to see if we can have a conversation here. And let me just say, I'm going to do an introduction. Then I am going to talk about what the state has called the resilience map. And we are in stage 2. We're going to talk about what that means. Then I would like to talk about the 3 Ps, the PPP, but it's not the money here. What I'm going to talk about is the planning for reopening, the preparing the workplace for reopening, and protecting the employees and protecting employee rights. The introduction. So, as an attorney, I look at the world through the risk of legal issues. And what I would like to do is to point out those legal issues that I can foresee, that I think, Chris, as an attorney, you also see, so our members can be mindful where there may be a legal issue. Because if they're aware that there is a potential legal issue, then they can take steps to prevent this from becoming a case or a claim from the legal perspective. And from the legal risk awareness and management, for the risk management point of view, there are 3 points that are key. And the first point being negligence liability. What does that mean? In general terms, in the United States, if you do something that causes harm to somebody else, or if you fail to do something that you should have done, and your failure to act causes harm to somebody, somebody can file a claim against you and request damages and maybe get damages. So that negligence, that failure to act, could get you into legal trouble if you do something or you fail to do something. And from the point of view of reopening, this is looks like, for example, if there is a guide from the state, from the county, that requires employers to take a step, and the employer doesn't take a step, an employee who gets infected could make the argument that he or she got infected because of the negligence of the employer and file a lawsuit against the company. Will that happen? We don't know. No one knows if there's going to be claims for negligence because of COVID-19 infections. But if we are aware that some people are thinking about that, then we can manage it when we rule our conduct, when we make decisions, when we take steps to go back and reopening, go back to work. The second area that is part of this legal awareness and being mindful is health and safety. In California, all employers are required to have an injury and illness prevention program, or IIPP. But I am willing to bet that if I go to your business and ask you, hey, show me your written program, most people will say, I don't have one of those, right? So now more than before, now more than ever, the state of California through Cal OSHA and other agencies are going to enforce those protections that employees have for health and safety in the workplace. So it is important to be mindful that we have to now comply with the health and safety requirements. Also, there's equal opportunity requirements that could be a source of risk. For example, people who are over age 65 have been identified by the Center for Disease Control, the CDC, as people with a higher risk. And the formal recommendation from the government of the United States is that people who are over age 65 should stay at home and not go to work, right? But if as an employer, I say, hey, anybody who's over age 65, don't come to work. We don't want you in the workplace because you have a higher risk of getting contaminated. Can we do that? Well, some people will say, absolutely, you can, because they are at a higher risk, you're doing them a favor. And some people will say, wait a minute, the law says that you cannot discriminate against people because of age. That is age discrimination. So you see, there is a risk that by taking actions to protect the employees, you may get into trouble with the anti-discrimination laws. The same goes for laws that protect against disabilities, medical condition, that require job accommodations. Those laws are still in the books, and we have to be mindful that when we make employment decisions based on reopening and going back to business, we have to be careful not to be in violation of those rules that protect rights of employees from the discrimination point of view, from the health and safety point of view, and finally, workers' compensation. The basic theory for workers' compensation is, of course, that when somebody gets injured at work, they receive medical benefits and they receive compensation if they cannot work because of a work-related accident. So the question is COVID-19, the disease, a workplace issue? And the answer is we don't know. So what I can say is that the governor last week issued an order, which is a statewide order, temporary, but it is now the law in the state of California that if anyone during this pandemic gets sick, it is presumed that it happened at work. It is presumed that it's a workers' compensation case. And that is significant because if an employee gets infected, we don't want anyone to get infected, but if an employee gets infected, then we know that it is more likely than not a workers' compensation case that is going to be handled by the workers' compensation system. And more importantly, and this goes back to the negligence point of view, if a worker receives workers' comp benefits, then they cannot file a lawsuit for negligence. So these are kind of related. So those are the risks that I foresee are in this going back to work reopening issues. And when we talk about the steps that need to be taken, I want everybody to be mindful and alert to those concerns. Second, we're going to make some recommendations in this presentation, and some recommendations are common sense, nothing that I need to tell you, you already know, but some recommendations may be useful. For example, my number one recommendation is that we need to designate a master of COVID-19 issues. Let me say that again. Someone in your organization has to become the master of COVID-19 issues. And the reason why I say that is because this is going to change. Sometimes it's changing just daily. So it is important for somebody to be looking out the window and paying attention to be careful and know when something has changed. Because if you don't, then you may run into legal trouble. So please designate somebody to be the master of COVID-19. If you're the business owner, it makes sense for you to be the master of COVID-19, but somebody has to be, because there are some guidelines that require actions to be taken by that person. And also, my second recommendation is that you communicate, and communicate. This is a time for transparency and flexibility. This is a time where we become a little bit vulnerable and we tell people that we're trying to do our best and we are communicating our decisions, and the more transparency and flexibility, the less of a chance of somebody pointing the finger to make a claim that you were negligent or that you failed to act if you communicate in the best way you can. Okay, speaking of the Master of Information, just yesterday, the County of Orange published a flyer, what looks like a poster. And Chris, if we can go to that. So This was something that was published just yesterday, and I don't know why they do this on a Sunday afternoon, but if you look at it, it is a resilience roadmap to the OC, which is what we're going to talk about now, the resilience roadmap. The state of California has taken the position that in order to reopen, the state is going to follow a roadmap, which is going to be divided in 4 stages. And the next stage is what they call stage 2, which means that some businesses are going to be allowed to reopen early with adaptations. Let me say that again, allowed to reopen with adaptations. And what that means from my perspective is that the state is expecting that some businesses, not all businesses, are going to reopen, and that any business that reopens is going to have some adaptations. And when we look at this stage 2 in the green, there are some businesses that are listed there. And when we look at the ones on the blue, it says not permitted in stage 2. This is really interesting because the County of Orange is at the forefront of reopening faster than other counties. But when you look at the list of businesses that are not supposed to be reopening this week, it's pretty long. So I expect for this roadmap resilience checklist to change this week, during the week, and for sure by the beginning of next week. So Chris, if we can take that down. I wanted to say we have a couple of materials that you should have received. This one you didn't receive because it's brand new and fresh, but we also have the checklist that it is intended to be a guide to use and to be able to check as we go along. And also there are some other things that you should have received, like for example, there is a COVID-19 general checklist for retail. This was published by the state on Thursday, which is intended to be a specific guide for a specific industry. And again, the checklist and some useful posters from the CDC, from the Orange County Department of Health, and some things that you can just use as part of your materials to comply with the guidelines. For example, this is the general guide published by Cal OSHA. My recommendation, just hand it out to employees and give it to them and let them read it and ask any questions and see if they have any concerns about what the guidelines say. So going back to the roadmap and resilience and stage 2. Again, this was rolled out by the governor on Thursday. It was published on Thursday, and they have a pretty nice website. And essentially what the state is asking for stage 2 businesses that are allowed to open is to do 5 things. The first is to have a detailed plan to manage the risk. So the first requirement is to have a risk assessment and a site-specific protection plan. And the requirement is pretty vague. Say, do a risk assessment and have a plan. But for example, I picked the retail industry because some of our members are in the retail space. When you look at the retail requirements and the checklist for the industry, which when you go to the website, it's more like this. This is the industry guide. But within the guide, there is the checklist. The first thing that they say is that the plan has to be in writing. Well, gee, so we now have to put something together in writing. Don't worry, it's pretty straightforward. It essentially tells you the checklist, what is it that the written plan must have. So my advice is to go down the list, put it in writing, answer the questions, and have it and use it. So if somebody asks, you can say you have it, you can show it to them. So that's one thing, you can put together your own written plan following the checklist by industry. And some industries are different. This is for retail, restaurants is a little bit different. Or you can ask your friendly neighborhood lawyer to help you put it together. And I'm sure they'll be happy to help you put together something in writing that complies with those requirements on the list. But be mindful that the state has a guide and there are some specific things that need to have in writing to manage the risk. Second, employee training. The state requires for the employers to advise employees on a couple of things. First, on the measures taken by the employers to prevent the spread of the virus within the workplace. So we need to communicate and train the employees on the steps that we are taking as employers to prevent the spread of the virus. Second is to educate them or train them in the prevention of the spread of the virus and simple things. We're talking about washing of the hands. We're talking about wearing face coverings. We're talking about physical distancing and all the measures that are being taken at the workplace to prevent the spread of the virus, and things that the employees can do to prevent the spread of the virus at home. Staying at home as much as possible, not coming to work if they're sick. And there are guides, posters, flyers from the federal government, from the state government, from the county. So if you put all of the guidance on the wall, you won't be able to see anything. There's so much. So my advice, just look at them and put up the one that you like the most or do your own. But definitely we have to engage in training with the employees, and we have to, as businesses are going to reopen, to take control measures. What does that mean? Well, we know that for retail, for example, it has to be curbside. So people cannot come in and shop. They will have to essentially find a way to order, pay, and have the order ready for it to be delivered outside of the premises to the customer. So the curbside, what does that mean? Well, from the operations point of view, curbside can mean many things, but from the requirement of the state of reopening, what the state is essentially saying is that when we adopt a curbside operation and we allow for this adaptation to take place, then we have to take measures to protect the employees and the public. Wearing of face coverings. This is huge because wearing a face covering has been determined by all the agencies to be a protective measure. So are we going to require our employees to wear face coverings? Absolutely. It's on all of the guidelines. Are we going to require our customers to wear them? Well, it is a best practice and it's definitely recommended. And also, do we put some barrier like plexiglass or some other barrier to protect the worker and the customer? Are we going to put some physical markings like tape or something to mark the distance of protection from people to keep that physical distance of 6 feet that is recommended? Anything that will help prevent the virus is a control measure that we should adopt, and more importantly, document. Let me say that again. It is really important as part of your written plan, put in the written plan those physical measures that you're going to take to adopt and document when they were taken. And if you ask me, it would be a good idea to take a picture. If you put some tape to mark the 6 feet distance, take a picture of it and save it. Put it in a file. Give it to the master of COVID-19. And that way you have a file in case something goes wrong. You can point to the measures that you took to adapt and comply with the roadmap of resiliency required by the state. Disinfecting protocols, not only cleaning, we have to clean more than ever and better. And in some cases, there are some deep cleanings that are required. Those deep cleanings are reserved for when somebody tests positive for the virus and somebody actually has COVID-19. There is a specific CDC way of cleaning, but most businesses are not going to have to deal with that, which is good news. But there's also a need to have a disinfecting protocol and frequency, and to adopt whatever frequency we adopt. It doesn't matter if you're going to do it once a day, twice a day, 3 times a day, but if you're going to do it. And it will be a good idea to have a record that it was actually done. And finally, the physical distancing, which the government officials cannot emphasize enough. It is important to find a way to allow people to be at least 6 feet apart, and ideally not more than 10 minutes in an interaction together, even in an office environment. Look, the safest, most secure office in this country, at the White House, there's people who have been infected with this virus, so no one is immune. It doesn't matter how many protections you take, the virus may come in. So this is all about trying to safeguard as much as possible and to take those measures to prevent physical distancing. So Chris, I think I see some chat questions. Is there anything that we should cover now before we talk about planning the first P?
Yes, there's a question. You mentioned earlier the governor's order and, in essence, making these kind of claims and kind of, as far as protecting our businesses, being workers' comp claims. Is that a good thing or a bad thing? I mean, if you're a business and you're worried about your protections, is Newsom's order to make it a workers' comp claim good or bad? How do you view that?
Yes, good question. That's a fantastic question. So to take a step back, what the governor did was to change the basic rule. The basic rule is that the employee has to prove that whatever disease the employee has happened at work. Now, there is an order of the governor that says that if anyone during this period of time gets infected with COVID-19, it will be presumed that it happened at work. And that means that when you go to workers' comp, the employer has to prove that it did not happen at work. And of course, it is very, very hard to prove a negative. Some people say impossible to prove a negative. And what is the consequence of that? The consequence of that is that more people are going to be able to claim workers' comp for COVID-19. Now, is that good? Some people say it is absolutely horrible because the workers' comp premiums are going to go up next year. So getting workers' comp next year is going to be very expensive. And now I'm going to have to deal with people in workers' comp coming and going and all the complications of having an employee in workers' comp. So some people say it's bad. Some people say this is the greatest news and best decision the governor has made, because if your friendly neighborhood plaintiff attorney wants to sue you and file a lawsuit against you, you can say, wait a minute, buddy, go to workers' comp, because when there is a workers' comp claim, there is no lawsuit. The workers' comp is the exclusive remedy for the damages caused by that industrial disease or accident. And from that perspective, some people say this is really good news because employers are shielded from liability, because now they can send people to workers' comp and forget about it. And they don't have to give notice to their insurance companies that they have a claim because the claim was sent to workers' comp. So some people say it's good, some people say it's bad. I personally think this is really good news for employers, that now they just shuffle their employees to workers' comp and forget about it. And the people will get medical treatment and benefits. So good all around, I think.
And Javier, there's a question from one of our, I think, based on the retail. If you own a retail store, is retail open for curbside only presently?
Yes, that's a good question. So what the governor says that low risk retail may open with curbside only. So that's the adaptation that is required right now. So people cannot come in and shop. They can only pre-order and find a way to observe the other protections and then do business. Let me be clear and take a step back. Some businesses are essential, and essential businesses have been in operation since March 19. So we're talking about non-essential businesses. And I don't know why. For example, on a personal note, I like bicycles, so bike shops are essential. I don't know why, but I've been to a bike shop twice since this crisis has happened, because it is an essential business. So we're talking about non-essential businesses here. And for non-essential businesses here, as of last Thursday, only with adaptations, only through curbside. But Chris, I can make a prediction. There is tremendous pressure from the public to allow the reopening of retail with adaptations, actual shopping in store. And what the roadmap calls for is for the county to make an attestation that they have complied with the requirements of the state as to number of infections, number of people in the hospital, and number of tests. And as soon as that happens, some counties are going to be allowed to take a wider, more open stage 2. The county of Orange is working on it, but they clearly said yesterday they're not ready. So I think that the county should make their attestation soon. I suspect Sacramento is going to approve it. And in my opinion, the county of Orange is going to be open for shopping before, actually, my opinion, way before the county of LA, because of the numbers. LA is not in a position to make the attestation that OC may be able to do. That's a long way to say, right now, curbside only, that's the adaptation. Soon, with adaptations, physical distancing and protections, the retail will reopen.
Thank you, Javier. So you're talking about next about PPP. Did I understand that correctly?
Yes, so I call it the PPP just to find a cute way to talk about something so you don't forget. Some people will never forget the PPP because they got it. Some people will never forget because they didn't get it. But in any way, what I'm talking about, the first P is planning. So planning is to make the decision, are we going to reopen, right? Are we allowed to reopen? So let us assume that the answer is yes, we can and we are. Then the next step is like, okay, so who is coming back? Are we going to ask the employees to return to work? Because most employees right now are not working. And that creates a conflict because we know that we cannot go back to business 100%. So if we cannot go back to work 100%, are we going to recall all of the employees? And the logical answer is no. We're only going to call back those people that we need. So how many employees do we need, right? And more importantly, who is going to come back? So in answering those questions, we have to be mindful, well, if we ask people to come back, we have to do it in a way that is non-discriminatory. And what that means is that if you choose somebody over another person, it is a good idea to have a business-related reason to justify why one person was called before the other person. And we also have to be mindful that in some cases, choosing one person over another person can cause a claim or a lawsuit. And let me give you a concrete and specific example. I am aware of a claim that happened like this. There was a business thinking of reopening, and they decided to bring somebody, and they brought that person, but left another person at home. And the person who stayed at home claimed that that employee was being discriminated against because that employee has children at home because the schools are closed. And as we know, people who have children at school when the schools are closed are entitled to receive emergency paid sick leave, but only if they're working. So the argument went that the employer failed to bring back that person because the employer did not want to pay the emergency paid sick leave under the Families First Coronavirus Response Act. And that is an act of discrimination, which is unlawful under the new federal law that allows for emergency paid sick leave. So somebody was saying like, wait a minute, I just wanted to bring my best employee and now all of a sudden I have a claim for discrimination. So be careful that when you choose to bring somebody back, it is a good idea to have a business-related reason to bring them back. So how are we going to bring people back? Well, one way to do it is to offer voluntary, to say, hey, anyone want to come back on a voluntary basis? And some people absolutely will. And that, of course, is always easier to manage when it's voluntary and people come back. But if you're going to be picking and choosing who comes back, be mindful of having a business-related reason. Now, the flip side of that, when we look at who are we going to bring back, and we choose some people over others, and we avoid discrimination, and we ask them to come back, and the employees refuses, and they say they don't want to come back. Now what? What do we do when we ask somebody to come back and they don't want to? And that's a difficult and sticky situation because most people are essentially out of work. So if somebody asks us to come back, the question is, can we fire those people? I mean, we have a job, right? And you should be willing and able to go back to work. In order for you to collect unemployment, you have to be willing to accept the job. If I'm offering you a job and you say no, is your unemployment going to end? So this is all related in a way. So my recommendation, my suggestion is that if somebody refuses to come back, my suggestion is to document the reasons why. And let me explain. We know that the law says that you cannot discriminate, but we already talked about that. But I want to share with you that the law also says that employees have the right to work in a safe environment. So the requirement of the employer to provide a safe working environment, can we provide that when there's a pandemic? And the answer is, well, the state is taking measures and adaptations to ensure that the workplace is as safe as possible. So this comes down to, and there's some guidance from the federal government, and there's a little bit of guidance from Sacramento as well, that says that an employee can refuse to come back to work if there is a direct threat to their safety concerning COVID-19. Let me say that again. If there is a direct threat of exposure to COVID-19, the employee may refuse to come back to work, and they are specially protected and they cannot be terminated. And if terminated, they're entitled to wrongful termination claim, damages, and all the bad things that attorneys do. So how do we ensure that we're not asking somebody to come back to a direct threat? Well, we follow the guidelines. We do the adaptations. We require the face coverings. We require the physical distancing. We disinfect, and we do all of those things that will prove that it was not a direct threat for people to come back in a low-risk environment with adaptations. But there are some businesses that for sure, if we ask people to come back, they may be facing a direct threat. So let us be careful, right? And I'm thinking of dentists. I talked to a couple of dentists. Doing a dental procedure is pretty up close and high risk. So can we ask a dental assistant to come back to work now? Maybe, maybe not. But the point being that most people are not dentists. So to answer the question, Chris, it is important to be mindful that if somebody refuses to come back, the initial reaction should not be to terminate the person. My recommendation is that we communicate and we document. And let me say what that looks like, to ask them, why are you not coming back? And whatever reason they say, then we explain the measures that we have taken to ensure that the place is safe. And then we communicate. I'll send them a letter to say, you refuse to come back. You said you refuse to come back for this reason. Let me tell you the steps we have taken to make this place safe as possible. And with these measures, you're welcome to come back if there is a job available to you. Let me say it again. If there is a job available, you're welcome to back anytime. That way, if you document that the employee refused to come back, if you document the measures and adaptations taken by the employer to make it safe, and you leave the door open for the employee to come back, if they don't, it's on them. If they do, and you have a job, we'll give it to them. If they do come back and you don't have a job, you tell them, look, I'm sorry, I had to hire someone else. I told you. You were the one who didn't want to come back. And that should give you a shield of protection against claim of discrimination. That should give you a shield against claims of retaliation, and it should give you a shield of claims of negligence because you're documenting the steps taken. But let's make sure that we are documenting the steps that we actually took, right? Because these steps are going to change from time to time. Now, what about unemployment? What should we do? Because the unemployment office, the EDD, sometimes calls and say, hey, what about Javier? Is he, coming back, or do you have a job for him? If the EDD doesn't ask, I wouldn't tell them anything and just leave it up to the workers, because the unemployment rules have been relaxed tremendously. In California now, anybody qualifies for unemployment, even independent contractors and gig workers. So I wouldn't touch the unemployment part of things unless asked by the EDD. So we were talking about the planning. Who is going to come back? How are we going to ask them to come back? How we're going to handle the people who are coming back, and more importantly, how we're going to handle the people who refuse to come back, right? But there is an area that is important to talk about, and it has to be with high-risk employees. There are some people, because of their age, over 65, or because they have a pre-existing condition that is at higher risk of infection from COVID-19, we have to be mindful of those employees that they need to be treated differently. So if you have an employee who's at a high risk of contracting this disease, you should consider providing them a reasonable accommodation. What does that mean? Well, the first reasonable accommodation is to allow them to work from home. But if work from home or remote work is not possible, then what? What can we do? Well, one idea is to bring them for a short period of time during the day, or to do shifts, or to ask them to do a different job. Or sometimes it's to give them more time and to allow them to continue to be furloughed, waiting to be called back to work. But it is important to have an interactive process or conversation with the people who are at higher risk, because those are clearly protected by the anti-discrimination laws, and that can be a source of liability, no doubt. So if somebody is at a higher risk because of their age, if somebody is at a higher risk because of a pre-existing condition, it is important to be mindful that we may need to accommodate those folks to avoid potential liability, because there is a specific requirement to treat them differently, especially during this pandemic. And there's some guidance from the Department of Fair Employment and Housing. There's a frequently asked questions, and for all of these subjects, there's some guidance from the government. So don't feel like you're on your own trying to figure this out, or again, call your friendly neighborhood employment lawyer. Chris.
Yeah, Javier, quick question. What the question is this? Sorry. So you talked about communications. You know, you got an employee at home. They don't want to come back to work for their personal reasons. They're concerned about the environment, et cetera. So what kind of, are there like forums for this stuff? What kind of communications as far as guidelines, et cetera? What would you, it sounds like you want to do it in writing, you want to communicate effectively. So to protect your business and liability, what would you recommend how to communicate effectively? Do you send them guidelines? What do you do?
Right, that's a good question. So there are checklists, there are flyers, there are posters on many of the requirements that we have to take to adapt and to protect and to educate. So there's plenty of those. But to answer the question, when we talk about communicating with the employees, there's not really a form. A form could be developed, no doubt, but this is more tailor-made, custom-made for the situation. So my recommendation, it can be a memo, it can be a letter, more formal. Please don't do a text message. Those are headaches to become evidence for attorneys, because as attorneys, we always think, how can this be a piece of evidence? You know, think Exhibit A, right? So don't do it over text, please. But the point is that find a way to communicate in writing what happened. And it can be very straightforward. It can be, you know, we ask you to come back to work and you said no. Why not? You said you didn't want to come back to work because, and given the reason. So we can develop a form, I guess, and, you know, the next paragraph should be the steps taken and the adaptations taken to make it safe. And then the last is what I call the law declaration. You tell them that you want them back, and that if there is a job available to them, they're welcome to reapply. So you leave it up to the employee to take action, and that way the employment relationship stays paused, right? You're just saying, look, you don't want to come back, we'll wait for you, but you have to come back to us. And if there is a job for you, we may give it to you. But the flip side of that is that if there's no job available when you come back, there's no job for you. So you don't have to fire them. You just have to put the burden on them to come back. That's what I would do. And in my experience, that has worked, because the people that really want to come back, they will, and they will cooperate. And that was that. But the people who are troublemakers, then you can use that piece of paper to protect yourself against the troublemakers, right?
Yeah, so basically, not just to give a plug, but I mean, if you're thinking of terminating an employee, you need to understand the guidelines, and it wouldn't be the worst idea to get if you have that access to consult your friendly labor lawyer, because we're really in a tricky spot as a business owner. You may have legitimate reasons, but you got to be careful. Is that fair?
Oh, absolutely. So what I'm saying, and to be clear, is that with most people, it is important to communicate and document. But with some people, those at a higher risk, we have to go above and beyond. For people who are over age 65, for people who have pre-existing conditions or serious medical conditions or disabilities, then we have to act. It's different. The burden is on us. You see, California is an employment at will state, and what that means is that the employer can fire an employee at any time for any reason, with or without a reason. So the basic rule is that you can fire people anytime at any time for any reason, as long as it is not discrimination, as long as it is not retaliation, and as long as it's not against the public policy. So let's run it down. Is it discrimination? We already talked about that. We're not going to discriminate. Okay. Is it retaliation? We're not going to do it because of punishing somebody related to the virus. Is it against the public policy? Gee, we're following all the guidelines. We're not doing it against the public policy of California. So what could it be, right? And that's why I say communicate and document. But separate from that, if the employee has a serious medical condition, if the employee is over 65, then the employer has to accommodate, has to do an interactive process. They have to offer an accommodation. And in those cases, we also have to document, we also have to put it in writing, send a letter, send a memo, not a text, maybe, and document that. I hope that makes it more clear. Make sense?
It does. And there's another question that this came in from one of our attendees. It's very specific to San Clemente, but just kind of wanted to get your take if you know. And I'll read it as such. There's a rumor circulating on Facebook that some San Clemente businesses, including some hair and nail salons that reopened last week and were closed, and had their license suspended for 3 years. Do you know if that's true? Have you ever had any other similar cases happen that you know of? So I guess the theme is businesses opening their liabilities. I guess, have you heard of something like that, or do you have any thoughts about that based on that question? Yes.
Right. So my response, I have not heard of specific instances of enforcement in San Clemente. And I know of one incident that there was enforcement, but the enforcement was limited to making the business owners aware of the requirements. What I can say about that is that the roadmap that the governor's office published do say that operating outside of the phases can lead to the revocation of a business license. So it is possible that the punishment for opening outside of your authorized zone, or the punishment for not following the adaptations, could be the revocation of a business license. But we have due process, and the reality is that it's a long road. So first there has to be an investigation, there has to be a finding, there has to be some sort of penalty, there has to be some sort of charge, and the administrative agency has to have a hearing, and you go before probably an administrative law judge. And so a revocation in a week, it doesn't happen. It doesn't happen.
Thank you.
I mean, I can foresee some really risky businesses. Maybe they will get an emergency shutdown, but they're going to get a hearing. I mean, at some point, even if somebody comes and closes the door, you're going to see a judge in a day or two. So has that happened? I don't think so.
Thank you. I appreciate that, Javier. We have about 15, 16 minutes left in the webinar. Can you talk about some other items you'd like to tell our businesses today?
Absolutely. So let's talk about the other two P's. The P of preparing, which I call it workplace safety. And under that area, what I would like to talk about is the guidelines, right? The guidelines from Cal OSHA. And the Cal OSHA guidelines, again, if you go to the roadmap, you're going to get some specific checklists to your industry. And these are pretty detailed. So my recommendation is that you follow these. But the CDC also has guidelines, and the states also have guidelines. So if you look at my checklist, you can spend all day looking at guidelines and checklists. Try to do that as much as possible, to look as many guidelines as you can, because there's a lot of overlapping steps and they're the same. But if you're going to follow something, follow the roadmap, because chances are that if there is an issue, it's going to be in California and California State Court or California government agency. And this is the California roadmap. And you see Cal OSHA, if somebody's going to show up in a van with a bunch of people with suitcases and cameras, it's going to be Cal OSHA. So if you have one of these printed, you show it to them. It's like, hey, I'm doing this. I haven't done anything wrong, right? So my recommendation is begin here with the roadmap, and then take a step back and look at what the county is saying, because the county is also putting some guidelines, and then look at what the federal government has said, because California typically goes above and beyond what the US government says. We usually have more than what the federal government has for other places, which then takes us to the issue of medical exams. There has been an exception made. Typically, you are not allowed as an employer to ask people about any medical condition. Let me say that again. Typically, you are not allowed as an employer to ask any questions whatsoever about somebody's medical condition. So even a basic question like, are you sick? Are you okay? Are you feeling sick? Those are illegal questions, believe it or not. But during this pandemic and national emergency, employers are being authorized to do a limited medical examination. What does that mean? Two things. Either a temperature check, so you can check the temperature of the employees coming into work, and if they don't have a fever, which has been defined as 100.4, and I don't know the difference, but I've heard that in other places it's 103. So the national one is 100.4. So if somebody tests above 100.4, you may ask them to go back home. A couple of things. If somebody shows up to work and you send them back home, you have to pay at a minimum 2 hours of pay, because in California, there is such a thing as show-up pay. If I show up for work, but I cannot work, then the employer has to pay at a minimum of 2 hours. So be mindful of the show-up pay requirements. And also, if you're going to ask people to take their temperature coming in, the time waiting to take temperature is compensable and has to be paid. And this is a case that has, have had implications for larger employers, really, not for smaller employers. So we either take the temperature or we don't take the temperature. But if we are going to take temperature, be mindful that you also have to protect the confidentiality of the employees. So it is important that if a log is going to be kept, it's going to be kept confidential as much as possible. What we don't want is to have a scoreboard and a list of other people and how the temperatures are happening and going up or down. We have to protect that information and to keep it confidential. Is it worth it to take temperature? Maybe, but you have to buy some equipment. You have to have some protective gear. You have to keep physical distancing. You have to keep a log. And there are some complications with taking temperature and an additional cost to the business in taking temperatures. So do you have to? And the answer is no, it's just a guideline. You may, if you want to. It is a good idea, but you don't have to, because the guidelines from the state in the roadmap, they say that you either take a temperature or you do an assessment. What does that mean? Well, it is essentially a questionnaire, something like this, that says, in the past 24 hours, have you experienced a fever? Yes or no? Have you experienced fatigue? Yes or no? Have you have a cough, sneezing, aches, pains, runny nose, stuffy nose? So you may ask employees to fill out one of these before they come to work every day, and you keep them in a secure, confidential place so that if somebody gets infected, then you have a record that you try to prevent the spread of the virus by at least doing an initial medical inquiry or medical examination. Now, there's also the obligation of disease prevention. And what that means is that if somebody tests positive for the virus, you have to alert the others, and in some cases, the county authorities, which creates a dilemma, because if somebody tests positive in your workplace, are you going to let others know? There's some privacy issues. Maybe people don't want for everybody to know that they tested positive for the virus. So there is some delicate areas that need to be dealt with if somebody tests positive, and there's some privacy concerns there. The best practice, and what I recommend, is to get a waiver from the person authorizing the employer to disclose the positive test. But even if the employee refuses, the guidelines call for letting all other workers know that there was somebody infected within their work area, because there are steps to be taken under the CDC guidance to deep clean, and there's maybe some quarantines ordered by the county if the person was in close contact with the infected person. And we have an obligation to help the health authorities. So if somebody tests positive, we may have to give notice to the county for the county to do the tracing. You see, one of the attestations that the county is telling the state is that they're going to follow up and make sure that they trace the origin of the virus so they can contain it, quarantine, stop it. Disease prevention. So disease prevention looks like being mindful of positive cases, and disease prevention looks like giving information, allowing people to hand wash as much as possible. And let me be clear, hand washing on the clock. Hey, I have seen some workplaces where they have those portable hand wash stations like you see on the beach or at a concert or something in the workplace. So not only in restaurants, but also throughout the workspace. Now, some companies are putting not only plexiglass, they're putting hand washing stations, sinks, wipes, soaps, all sorts of cleaning and disinfecting stuff. And of course, physical distancing, plexiglass, plastics, and so on and so forth. So Chris, I have one more P, which is protecting, but before we go there in the time that we have left, any questions about the preparing?
No, I'd go to the last P. I think there might be some questions at the end, Javier.
Great, so let's talk about protecting the employee rights. And I already talked about this. I covered this already, but it's important to me because this is the world that I live in, the employee rights world, right? So from the employee rights, we have to be mindful of the health and safety, which is we need to now have the plan in writing. We need to take the steps to have the adaptations in place. We need to take the steps to provide education. We need to take the steps to allow for hand washing, to provide the materials, the face coverings. If we're going to mandate for people to have face coverings, are we going to pay for them, right? And let me be clear, we're not talking about masks. These are not N95s or actual surgical masks. We're talking about face coverings, so it can be anything. But if we're going to require it, are we going to pay the employees for it? And the answer is like, well, it depends. If you ask for a specific kind, then you have to pay for it. So if you say it has to be this one, well, you have to pay for it. But if you allow anything, then you don't have to pay for it. But it'll be nice. Some people will appreciate it. Are you going to ask your customers to wear face coverings? Are you going to provide face coverings for customers? And more importantly, if you're using disposable face covering, ensure that there is a proper way to dispose of that as biological waste, because it could be infected. Privacy, huge. California has always been very, very strict on privacy. So we have privacy concerns about diagnosis. We have privacy concerns about testing. We have privacy concerns about medical inquiries, because if we're going to ask them to fill out a questionnaire about how they feel medically, we better keep this private and secure and the information protected, because people may have a claim for privacy violations. Wage and hour, making sure that everybody gets paid for the time that it takes to prepare to adapt, making sure that people get paid for every hour that they work, not only in the physical space, but also working from home. For those people who are working remotely, we have to ensure that they are aware that they're entitled to work, to be paid for every hour that they work. What does that mean? Well, I have heard that some people are working more now than before because they don't have a commute and they're always connected, they're on the internet, so they end up working more than 8 hours. Well, if you have an hourly employee that is working more than 8 hours, you have an overtime risk. So one way to manage that risk is to set up an expectation and to say, look, we expect you to only work 8 hours. We expect you to keep schedule, because nobody's waking up at 6 in the morning, right? People are waking up at 8, 9. So it is important for us to give them guidance and say, look, you can slice your day whichever you want, but do not work more than 8 hours. And I know of a national accounting firm that has a software that the laptops shut down after 8 hours. They say, that's it, you're not going to work more than 8 hours. So there are ways to ensure that people don't work overtime, or if they do, just pay up. Just let them know, look, if you work any overtime, we're going to pay it. Make sure that employees know that they can take breaks, meal breaks, rest breaks. And for those that are coming back, one thing that is important for me is for exempt employees, those employees who are paid on a salary basis because of the duties that they perform. In California, we have 2 reasons, right, that need to be present. Because of the work that people do, they may be exempt on a salary basis. And also there's a minimum wage requirement. So they have to make a certain amount of money no matter what. And they should not spend more than 50% of their time doing physical manual stuff. Let me say it again. Salaried people are not supposed to be doing physical work for more than half the time. So if now people want to help and pick up the slack and all of a sudden they roll up their sleeves and end up working, doing physical work, be mindful that they may lose their status as salaried employees and then now may be entitled to overtime. And this is a big deal because you may end up with a claim when a practical solution is just to tell people they're going to be hourly while this emergency is happening and then just do a change for the time being. So any change in salary, any change in pay, any change in bonuses, any reduction in pay, or anything related to wages, medical benefits, or anything that is not going to be available because of the national emergency, please, please, please put it in writing, document it, put it on the file so there are no surprises, so people know exactly what is going on. And more importantly, there are some leave requirements that are new. The emergency paid sick leave is new. It's still available until December 31st. From the last webinar, we have to put up a poster so everybody knows about the emergency paid sick leave. And there are also some other leaves that employees may be able to take. In California, there are a couple of leaves that are available for people who are dealing with the actual virus. So be mindful that some people may take time off or a wage replacement because of a positive diagnosis of the virus in their family, dealing with their family members. So Chris, I think that covers the protecting P of the presentation.
Yeah,
And,
a quick question, Javier. They say, we could talk about masks a little bit. Let's take a scenario. What if you're going to go into a longer client meeting? I mean, do they have the right to ask you for a mask? Do you have the right to ask them for a mask? Tell me can you give some scenarios that businesses might occur based on the present law? Do you have any feelings about that and mask wearing? I know like our firm, we're certainly providing masks to our employees as available. I mean, what are your thoughts as far as masks and how those situations will be handled?
right, that's an interesting question, Chris, and here's why. If we look at the guidance for the adaptations, the state is discouraging in-person meetings. The basic go-to is to do it virtually, so they discourage in-person meetings. So if there is a need to have an in-person meeting, if you're part of the critical infrastructure, well, you're exempt. You're part of the critical infrastructure anyway, right? And some attorneys do give support to members of the critical infrastructure so they can do that. But let us assume that this is a non-critical meeting, right? What can we do? Well, observe physical distancing to the extent possible. I guess have less people in a conference room. Pull out chairs. So for example, I'm sitting in a table that has 10 chairs. So I guess I could pull 5 out and say, okay, only 5 people on this table. Wearing face coverings during a meeting is going to be very uncomfortable. But I've seen people sitting, talking to each other with a face mask. So it is possible. But I think the best practice is to keep it short or to take breaks because the guidance is people should not spend more than 10 minutes together, right? I can't hear you, Chris. I don't know why.
Oh, sorry, my bad. My Zoom error. I apologize. Just real quickly, because we're running out of time. I just want to let you know that we are going to post some of these materials on the website at www.scdba.org, and certainly contact Javier or ourselves with any materials that you would want from this thing. With that, Javier, any final comments?
Oh, my final comment is that, if anybody has a question, comments, concern, just shoot me an email, call me, I'll answer any question within reason, because this is terribly confusing, unnecessarily so. At the end of the day, let's not get too worked up. This is common sense, and we document our common sense decision. If you put it in writing and the writing shows that you were following common sense, you're not going to get in trouble, and your friendly neighborhood attorney is going to get you out of trouble. So don't get a headache now. But compliance is important. So definitely the DBA is here to help, so we can help in any way we can.
Well, thank you, Javier. Thank you on behalf of the Downtown Business Association attendees. Thank you for everyone attended this very informative webinar. Javier, thanks for your time. It's really appreciated by us all. Thank you.